Good afternoon. We're going to go ahead and get started. We have one bill on the calendar. It's Representative Stinson, HB 1417. Good afternoon. You can proceed when you're ready.
Well, good afternoon, committee members and chair lady. Thank you for giving me the opportunity to present to you this afternoon House Bill right. I just realized the clerk's office gave me the wrong bill. Okay, thank you. Thank you. House Bill 1417, LC 570104. And let me just make sure I put it on the record that I am not an attorney. This bill have no intentions of singling out any district attorney. There's no ill will toward any prosecutor in this state of Georgia. This bill is only being offered in the spirit of fairness for all of Georgia. House Bill 1417 basically makes it where doing a grand jury proceedings, it's not changing the grand jury proceedings. It's only stating that in any indictment proceeding before a grand jury, the accused and his or her counsel shall have the right to be present during the presentation of all evidence and alleged statements of the accused on the proposed indictment or special presentment. And basically just making it where the grand jury will not only hear from the prosecution before they decide to move on a case or not to move on a case, but they will also hear from the defense. So basically that's what this bill does. It does not change the way grand jury proceedings are currently conducted here in the state of Georgia. It's only giving the defense an opportunity to present to the grand jury. I just think it's only fair that the grand jury hear not only from the prosecution but the defense, because they are making a decision whether to true bill this case or no bill it. And I just think before they make that type of decision on someone's life, someone's future, that will impact their family's future, that the grand jury have a chance to hear both sides of the story before they move on any indictments or not. Now, I know that some feel that this is time consuming, and I imagine could be, because I'm not an attorney once again. But when I think about people and their futures, and it doesn't, again, is not changing the way the proceedings are held. It's not. It doesn't matter. I'm not getting into the type of crime. That's not an issue for me. It's only stating that the grand jury have a chance to hear from the defense before they make a decision.
Okay, thank you.
Mm-hmm.
Any members have questions? Chairman Leverett.
Thank you. Thank you, Madam Representative.
Yes.
I don't recall you appearing before Judy non-civil.
This is my very first time in 12 years.
Congratulations. We're
Thank
glad to
you.
hear.
Thank you.
So I'll invoke the hazing ritual we usually have. No.
Oh, no.
Thank you very much. So if I understand it, your bill says the accused can't be compelled to testify before a grand jury, but would have the right to be present during the presentation of all evidence. So they could be in the room, and then they would also be able to speak at the end of. They could cross-examine state's witnesses and then could present evidence, but they don't have to.
That's right.
And if they do present evidence or if they testify, they are subject to cross-examination by the state in the grand jury.
That is correct.
Okay. I've sat on a grand jury or two. I don't do any criminal work, but that does seem like a pretty big change from the current process, isn't it? I mean, right now, the defendant, I don't think, can be in the room and can't present evidence.
That's correct. Okay. They can.
Okay. All right, well, thank you.
Thank you for the question.
All right, thank you. Any other members with questions? I don't see any, but I do have one person signed up to speak.
Sure.
Okay.
Mm-hmm.
PAC, Prosecutor Pete. If you can, Thank you.
Thank you, Madam Chair. I appreciate it, and thank you, Representative Stinson, for bringing this bill. And as a former prosecutor, I take no offense to us having conversations about what the law is and how it should operate. And just a brief history for those of you who don't know what the grand jury does. The grand jury is an accusatory body. That is, it only needs probable cause to make an indictment, to issue a true bill of indictment. It's comprised of 16 to 23 citizens, and the foreperson is elected from that body. So the 16 to 23 citizens come together, they elect their foreperson, and then you bring in witnesses to testify before the grand jury. Typically, the witness will be the investigating officer. That will be the only witness you bring in. Now, prior to joining PAC in 2018, I was a district attorney for 25 years in a 5-county circuit, which meant I sat through and helped advise hundreds of grand juries, if not over my 32 years being there, probably 1,000 grand juries, because 5 counties, multiple grand juries, 1,000. I will tell you that one of the problems with this bill, and I should point out the DAs have voted against this bill almost unanimously. One of the problems with this bill is simply going to be who decides what evidence will be admissible, and what happens when you get into this grand jury session and all of a sudden you have a defense attorney in there and he or she is objecting to that evidence. Who makes that decision? Do you stop the proceedings and go in front of a superior court judge to decide what should be admissible and what shouldn't be admissible? And if the defendant chooses to question witnesses or the investigating officer testifying in front of the grand jury, are you going to have a court reporter there? Who's going to pay for the court reporter? If the court reporter's in there and the defendant is represented by an indigent defendant, is the county going to be responsible for paying for that? Also, I will tell you there are metro circuits which have multiple grand juries going at the same time. You already have a caseload that is backlogged. You already have prosecutors who are short-staffed and are trying to keep up with this caseload. By allowing defense attorneys to come in and defendants, you are going to slow that process down considerably. And let's remember, if a grand jury issues an indictment, you still have the discovery process in which if the defense attorney opts in, they are entitled to the DA's entire file. Now, even prior to having the discovery process that we have today, my policy was once we got an indictment or we filed an accusation, the defense attorney was automatically entitled to the entire file. I understand what Representative Stinson's doing, but this has major consequences on slowing down the system. Many states, Georgia's one of the few states that requires a number of cases to go before the grand jury. Many states have done away with the grand jury system altogether, and you can file by information or what is called an accusation here and proceed on to court, where you do have the evidentiary process going. You do have a judge listening to what evidence is admissible and inadmissible. And for those reasons, the DAs oppose this.
All right, thank you. Chairman Leverett has a question.
Always Chairman Leverett. So, do you know if any other states that still have a grand jury system allow the accused to address the grand jury?
Chairman Leverett, I do not. We do have cases here. For example, if you're indicting a police officer, they have a right to be before the grand jury.
Commissioners.
It may be the county commissioners. We changed the law some time ago, but
Oh, you did. Okay.
we took that away. So
Took
county
that away.
okay.
Used to have that.
We used to have it because I indicted a county commissioner in my first term in office. While I was running for office. I'm sorry, I'd just been appointed. But I don't know of any grand jury that allows defendants to come in. Now, I do know that if you bypass the grand jury in some states and file an information or what is called an accusation, you're automatically entitled to a preliminary hearing in front of a judge.
To determine if there's probable
Right,
cause.
to determine if there's probable cause.
One other question. Do you know, is there, I sense part of the concern of the sponsor here is allowing the grand jury to hear the other side before they make a charging decision. And I understand, I think your position probably is, well, this is not a conviction. It's just just is there probable cause for the case to even move forward? The grand jury is supposed to be a check, but you don't have to necessarily prove your whole case with all the detail during the grand jury. If you did, you'd never get out of it. Grand juries would go much longer than a week. But is there anything that, just, and I'm hitting you here kind of flat-footed, that you think could be done to maybe address the concern of the sponsor, like allow the accused to have a affidavit that got read into the record, or anything that might be tolerable from the perspective of the prosecutor?
Again, because here's my problem with having the accused have an affidavit that's, well, that would be I wouldn't mind the accused having an affidavit read into the record if I could use that affidavit to cross-examine the accused when he or she testifies if they change their story. I can't think of any, and I don't want to speak on behalf of criminal defense lawyers, but they typically don't want their client to say anything. Yeah, so that would not slow down the process. Obviously, you can't cross-examine an affidavit, but that would not slow down the process. But really, I think we should really have a study on the grand jury system in Georgia. More and more grand jurors do not like serving for a long period of time. They want to get back to their businesses. They can't understand why we're indicting all the cases that we're required to indict in Georgia, and they really want a process that is slimmed down to major felonies, and they understand they're an accusatory body. And the whole reason the grand jury system was developed was to be a check on the state, to be, like you said, a check on the state. But that was particularly when you had the appointment of prosecutors as opposed to the election of prosecutors. And now, quite frankly, prosecutors are so busy, and I can only speak for myself and my colleagues, that we're just too busy to really, I say try to mess with people, but I know there's going to be some guffaws behind me saying y'all mess with people all the time. So I'm just know that I was too busy to mess with people. I needed to, we dismissed the cases that we didn't want to go to grand jury. If we could put them in an alternative court, or we could hold what was called the warrant in abeyance, we would do that. And the cases that we indicted were the cases that we believe we could get guilt beyond a reasonable doubt.
Any other questions? All right. I like what you said. I think we need to look into the grand jury system, and I think that that's worth doing. So thank you.
Thank you.
All right. Okay. So on that note, Representative, we're going to keep this as a hearing only, and this may be one of the shortest judiciary hearings. So congratulations being through judiciary, but we'll keep it as a hearing only today.
May I give some final remarks?
Sure, of course.
All right. Well, thank you, Madam Chair, and thank you so much for your comments and the point that you brought out about maybe we need to take a look at the grand jury, and I'm certainly open to a study on that if that's a possibility, because that is certainly my intent, Chairman, is to get it where the grand jury can hear from both sides before they make a decision. That's all. Just being able to hear from both sides before they can make a decision on whether to move a case forward or not. So, but thank you for your time, and I look forward to further discussion.
Thank you so much. And Chairman Smith.
Representative Stinson, when is that Strawberry Festival again?
April 27th, the last Saturday in April, and the parade is that morning.
Right.
So please mark your calendars to be there so you can
Okay.
see me live in action in the parade.
Hey, thank you, thank you, thank you. Madam Chair, if I can just take one moment of personal privilege. I have two of my constituents here today, Mr. George Chambers and Mr. Caleb Chambers. We're going to get him to come page over in the House, but Mr. George was county commissioner for the Bowden area for a long, long time, 16 years, and miss him a whole lot. Appreciate Danny Bailey coming in to take up where you left off. So thank y'all for being here, and I know Caleb's wanting to go to law school, so we wanted to make sure he got a little experience today.
Welcome. All right, thank you. We are going to start the full non-civil Judiciary Committee at 2:30. And with that, we're adjourned.